So my name is Ethan Katsh. I used to teach at the University of Massachusetts in Amherst. My long ago background was in law and technology, not in dispute resolution. But I had a colleague, Janet Rifkin, who was one of the earliest adopters of ADR, and we collaborated, basically joined our different expertises and came up, I think, with online dispute resolution. So I'm grateful to Michael for inviting us and to Jim for inviting us. And a few lessons learned from online dispute resolution, or as it's commonly called these days, ODR. So one of the lessons we've learned is that it's best to focus a little more broadly, not simply on resolution, but on the generation of disputes and the prevention of disputes, because both of those elements provide guidance or insight into how to resolve disputes online. And I hope that's clear that that's our goal, technology-assisted dispute resolution. Most of the time it would be online, but if it's taking advantage of technology, we're comfortable putting that in the package as well. Many of you probably know that the internet was invented in 1969. It's interesting, to me at least, an interesting historical fact about disputing, that there were minimal disputes between 1969 and 1980, a handful, or at least a handful that we could put our hands on. And that changed radically in the 1990s. So ODR is really traceable to a series of changing conditions in the online environment in the 1990s. And I hope you can see on the screen what they are, but the most significant one probably is the one near the top, 1992, the lifting of National Science Foundation prohibition on commercial activity. So for the first 20 or so years, the net was the bailiwick of academics and the military. And whenever disputes arose, they settled fairly informally by themselves. Commercial activity, if there were a ban on commercial activity currently, it would probably fall in the category of a First Amendment violation, but no one paid attention to that back in the 70s, 80s, or early 90s. But there was a lot of pressure to lift this prohibition in 1992. And the resistance turned out to be accurate. The predictions had been, one, that this would generate a huge amount of commerce. That turned out to be true. Another prediction was it would end up with a lot of pornography. That too turned out to be true. But it was not simply the lifting of this prohibition, but the effect of lifting more prohibitions that schools had on access for college and high school students. And of course, there was really no way for the general public to access the internet. Those were the days when CompuServe and AOL and Merck Online were the ways to access private networks. But it wasn't until the mid-90s that they were collapsed into or accessible from the internet. My own interest in this, I suppose, started when I kept having high school students come to my office telling me they were thrown off of AOL and they wanted me to do something about it. And turned out AOL was not totally resistant to the idea, but I'm not sure I understand why these high school students weren't embarrassed to come to me and admit to all kinds of objectionable behavior. And lastly, the increase in number of domain names. If you think about disputes as a function of transactions and relationships, which is how I look at this, number of domain name transactions or was from a few thousand in 1990 to a million 10 years later, and 20 years after that, 360 million. And of course, the beginning of the World Wide Web. So in summary, this is a more general way of looking at what was going on, but we just didn't have a lot of conflict or need for any formal kind of dispute resolution in those 20 or so years. And many of you are aware that late 70s to overlapping the same period was the growth of alternative dispute resolution. And surprisingly, perhaps, not surprisingly, perhaps, the growth of ODR didn't really link up with ADR. We can surmise why that happened. One reason is that the ADR community for quite a while had almost a permanent belief that dispute resolution had to occur face-to-face. Some in the audience may disagree with that, but that's my impression at least. And ODR was not occurring face-to-face. So I'm going to try to finish up in another 10 minutes, but there was one more reason there were few disputes, and that is that disputes just weren't on people's radar at the time. People were so enamored with the capabilities that the net provided that everybody was looking at how to exploit the net for good. And here's one quote from a famous entrepreneur, but while this is embarrassing to him, he wasn't alone. No one anticipated there would be disputes, at least for a couple of years. And when disputes did become problematic, one thing that we found, might say another lesson that we found, was that while the ADR community wasn't enamored of ODR, much of what they were doing seemed to us relevant to ODR. In other words, computers could do many of these things that mediators were being taught to do: identify interests, acknowledge positions. Actually, all of the approaches that had become popular in the ADR community in the mid-'80s or in the '80s seemed to be capabilities that we could transport to the online environment. We could do that because we seemed to us that computers could do much of what mediators do. Obviously not as easily and not as well, but mediators, online mediators could do it at scale, or at least online techniques could do it at scale, and mediators offline were meeting face-to-face. But I think it was a critical lesson that it was necessary to control interaction and communication. And computers could do that if they were programmed. Well, sorry, going the wrong direction. So here are three examples among a whole bunch, but going from simple to more complex and then back to something in between. CyberSettle was a two-party blind bidding piece of software. You can call it an algorithm if you want, but it was a transparent algorithm in the sense that it asked two parties who had a dispute over money, pick a position, don't tell anybody, and the computer was programmed if the positions put forward, if the amounts asked for were within a certain range, the parties agreed ahead of time to accept the resolution. Very simple I had thought at the time this would be used widely. Turns out it wasn't used widely. Ran into resistance from a whole bunch of established communities, starting with the insurance industry. But it was a clear lesson on what computers can do with simple problems. And of course, what was being done within CyberSettle could be done by human beings, and certainly it was being done. Had been done by human beings probably for millennia, but this could scale. So you could do millions if there was a demand for it. Building on this was a company called SmartSettle, which still is in business, and SmartSettle expanded the blind bidding process from 2 parties to many parties. I don't want to get into describing it in too much detail, but essentially it asked parties what they wanted, had them rank them, and if the parties came to a resolution, the algorithm that's up on the screen, or you're seeing mentioned, that algorithm told the parties, or presented the parties with a solution that was it considered better than the solution of either respondent or claimant. And that was pretty impressive. And SmartSettle is still there. You can play around with it online. It hasn't been hugely successful for a couple of reasons, but one reason is it's fairly complex to use. But if you're willing to engage in it and spend some time with it, it's pretty interesting. And then, of course, eBay, which many of you are probably aware of, is the poster child for ODR. Beginning in 1999, eBay saw that its original business model was not really, had issues. And the issues were mainly one of lots of disputes, but also one of trust. And we'll talk about trust in a second. But dispute resolution for eBay came about because it wanted to know whether disputes could be mediated online. And these were buyer-seller disputes. How can you do 60 million disputes? Well, if you do this, namely control interaction and communication, and let the computer do that, then there's no limit to how many disputes can be resolved by the 2 parties. If that wasn't clear, eBay operated with forms. So basically you checked off. It didn't like when you, didn't like free text. It wanted to control or constrain the conversation. And it did that by presenting the parties with choices. These were choices about a certain number, maybe 5 to 10 kinds of problems that could arise, broken something or delayed something. And by managing the flow of information, it was able to reach a solution. So one big lesson we learned from eBay, from all of these, is that solutions online need to be have at least 3 elements. They don't have to be there in exact proportion, so the triangle doesn't have to look like this exactly. But it does need to build on trust. It does need to have expertise. You could call that intelligence if you want. And it needs to be convenient. It needs to be efficient. It needs to save time and be easily accessible. What happens if you don't have one of these? Well, either it doesn't work or it doesn't scale or won't be used. And there was a story in this morning's New York, not New York Times, but Boston Globe about restaurants. And the restaurants are configuring there's spaces. So this is the expertise part of it. But down in the article is this line, complimenting the company that's helping them really shine the spotlight on the importance of trust in the relationship between the customer and the restaurateur. You don't see the mention of trust too often as an element, but here the guidance is very clear. eBay had this problem right from day one. Why would anybody participate with them? It was an easy system. They could buy anyone something cheaply, but there was always some risk. So the trust element relates to risk, and you don't want to have a system that's at all, that's not risk averse. So where are we today? Well, we have a lot of examples of ODR. I don't want to spend time discussing each one of these, but Alibaba claims to resolve 100 million a year, so eBay's been overcome. League of Legends, an online game, has 67 million users. They use online juries to control behavior. And I'd go to the bottom just to mention one that interests me a lot, electronic health records. Each of you, I'm pretty certain, if not each of you, then 95% of you have access to your electronic health record. And like many other online records, there are errors there. So how do you correct errors in these individual records? It turns out to be extremely difficult, but this is, I put this as one of the lessons of ODR, that there are records about us all over the place, and big opportunity to figure out how to correct online records. ODR in recent years, ODR started with the private sector, e-commerce. Lately, it's branched out into the public sector. You have big successes in England with Her Majesty's Online Court, and in Canada with British Columbia Civil Resolution Tribunal. And down at the bottom, you have what is for the ODR field, well, for the humanity, a disaster, but for the ODR field, a big benefit in that what do you do when the physical courts are closed? How do you handle cases? And ODR is the way to do that. But if you go back to my earlier point about generating disputes, we haven't been reading all that much about that, but here's again from the front page of this morning's Globe. Hundreds of mass workers say companies fail to protect them from coronavirus. We're going to have an incredible variety of disputes emerging from this pandemic. And lastly, what can AI provide? Well, I'm more in the learning mode than the prescribing mode, but can we ever resolve disputes by tapping on the screen? Well, of course, we resolve a lot of disputes online. We resolve Amazon-related disputes online. We resolve all kinds of disputes online. Basically, when we're not talking to a human being on the phone, and we reach the point where we occasionally ask whether we're talking to a human being on the phone. So I think I'm very intrigued by AI, but I still would suggest that it's necessary to have those three elements in any product that's provided, namely expertise, intelligence, trust, reduce risk, or efficiencies. And one way of preventing disputes is the line at the bottom. If you collect enough data, you should be able to figure out what kinds of disputes can be resolved and how you can do that. So I've taken a little bit more than 15 minutes, I think. So our next speaker is Colin. Are you all set?
Ethan, before you hand it over to Colin, this is Mike Wheeler here. Thank you for setting the table here in terms of the history, the genesis of ODR, and I know that Colin's going to build on that. But just for reference, CyberSettle, I had some connection with them. I wrote a HBS case on them. This is the blind bidding system where if you had an insurance claim or whatever the case may be, you could put in your, dream offer, and the insurance company would likely put in a lower one. You get a second chance at it. And the thought was at some point, you may get a zone of possible agreement, because if you are deadlocked, you don't know if you're deadlocked by $1 or $1 million. So it's an interesting strategic game about how you can get in an infinite hall of mirrors in terms of thinking what the other person is going to bid. The more demanding you are, the better you might do, but the less likely that you'll succeed. So it's very nice kind of illustrating the analytics on it. I once had the great good luck to be 3 offices down from Al Roth, who subsequently won the Nobel Prize. He felt that everybody, Ethan, should make the same offer all the way through. I thought there was an option value to being bold at the outset. If you had to bet on Al Roth or me being right, I would say put your money in Al, not me, but we had an interesting debate about that. So this gets to the design stuff. I just wanted to add that I'd had some familiarity with CyberSettle, and I know a GE company that's adapted its own form of that for what they regard small disputes for things under $100,000. So there's still some action on that. So I'll go silent again. Great to see Colin nodding his head. I'm looking forward to hearing from the next 3 people.
Yeah, and Mike, we're going to get into that in my presentation too. That's the hard thing about being at Harvard. You have an argument with your office neighbor and they say, well, where's your Nobel Prize? So, well, what can you do? All right, well, let me dive in. Ethan, no problem going over. That is your right as the father of the online dispute resolution field, but we've got an embarrassment of riches to get through. So I may go a little bit fast here, but I want to make sure we have lots of time at the end to talk. And I see we got a lot of very smart people and a lot of friends on the call, so I'm eager to hear people's thoughts. I'm not even going to bother to go through this. I think probably 90% of the people on the call could do this slide better than me. But I think all of us know within the dispute resolution field, this is kind of the palette from which we paint when we do systems design. Everything from direct negotiation to mediation to MEDARB to arbitration to private judging. When we're designing an appropriate resolution process to fit the forum to the fuss, these are the elements that we often think about leveraging, either alone or in sequence. And we think about process control, we think about outcome control. The thing that's interesting in online dispute resolution is we actually decide more about how our parties communicate with each other. So not only are we deciding, is this appropriate for negotiation? Is this appropriate for MEDARB? We're also thinking, well, are the parties ready to interact with each other through a video conference? Or are they just emotionally not at a place where that's a good start? So maybe we should focus on asynchronous text-based communication. Maybe we should focus on resolving some of the issues through a synchronous audio process, and other issues we should put into a discussion environment or an online collaborative workspace where we can work through the spreadsheet, for instance. So there's some interesting systems design questions that get in because we're actually designing the process through which our parties will communicate. And that introduces some very interesting dynamics in terms of asynchronous text-based interaction that can give a lot of new capabilities to negotiating partners and to mediators. So in ODR, as Ethan mentioned, when we first started this field 20 some odd years ago, we thought we would just take offline dispute resolution and put it online. The first online mediation process I built in '99 was literally stage by stage the exact mediation process I had been trained by the Quakers when I was first trained in mediation. Maybe 7 or 8 years before. But what we started to realize was technology gave us new capabilities that actually expanded the potential for dispute resolution. And none of these are going to be out of left field for people who have a lot of experience with alternative dispute resolution. But because you get access to disputes so much earlier in their life cycle, you can really help to set expectations. And this problem diagnosis, there's a little bit of theory around pre-negotiation in the dispute resolution field. And I know in the multi-party field, we do conflict situation assessments. But at eBay, when I was running online dispute resolution there, we actually got access to disputes before the complainant even notified the respondent they had a concern. And that gave us an enormous amount of power to be able to go in and help diagnose these issues and really set the frame around the ZOPA. So obviously, direct negotiation, that's what we're talking about here. Mediation is just assisted negotiation. But there are ways that technology can assist a dispute resolution process in ways that a human third party cannot. And then I say evaluation as opposed to arbitration because there are a lot of very creative ways. Ethan referred before to these online juries, sort of a fusion between crowdsourcing and e-democracy and a justice system that can give you efficient, scalable, evaluative outcomes, but they're not binding in the sense that an arbitration is binding. So I want to whip through and just give you some examples here. It's just going to be kind of a rapid fire presentation on some of the things that are going on in ODR, particularly around technology assisted negotiation. But one of Ethan's many imprints on the field of ODR, not only just naming the field and creating the National Center for Technology and Dispute Resolution and the pilot at eBay, he created the concept along with Janet Rifkin of the fourth party, which obviously is the notion that technology can be a player in a dispute. Party 1 and Party 2 are the disputants. Party 3 is the human neutral, mediator or arbitrator. Technology is the fourth party. And I put this little happy picture of a robot there because you could sort of picture the robot sitting, I mean, it doesn't have to be a robot. It could be sitting in the chair next to you. It could be a little Amazon Echo or Siri, or it could even be just an algorithm floating in the cloud someplace. But the point is the fourth party has capabilities, and those capabilities are expanding constantly. It's always in your pocket, and it has the ability to do some things that a mediator can't or at least shouldn't do. So what do we rely on the fourth party to do today? Well, many things. We do intake and diagnosis and case management, payment processing, administration, notifications. Everybody's uploading tons and tons of information. So now the fourth party can save all of that, make it available for us, send out calendars and reminders, and it can assist the negotiation in some limited ways, like Mike was talking about with CyberSettle. But the real question is, what is the fourth party going to be able to do tomorrow? Because as we all know from Moore's law, about every 2 years, computer processors double in power. So that's a logarithmic expansion of capacity. Eventually, we're going to have quantum computing. So what are we going, right now, we drive all of our cars. And I think we can all imagine a future where our grandkids or our great-grandkids think it's insane that humans were driving their cars. And every time that a semi-truck driver sneezed, he could take out 3 Hyundais. It's laughable to think how dangerous that is from the perspective of a future generation. We're going to learn to trust the algorithms to do things better than we can do them. And that's because the fourth party is getting smarter all the time. So we don't think about the fourth party in terms of driving our cars, but we do think about the fourth party in terms of doing research, helping us evaluate our cases, coach us, reframe our sense of what our BATNA is, enforcing potential outcomes. That's an enormously powerful thing that the fourth party can do. Drafting documents for us, submitting those documents, and then this whole notion of automated negotiation. So I'm going to go through some examples of how this is starting to happen today. But the real question is not really where we are today, it's where is all of this going? Because if you squint a little bit and look into the future, it's pretty exciting what the fourth party is going to be able to do soon. All right, so let's dive in. This is an example of a diagnosis wizard. So I talked before about diagnosis, negotiation, mediation, and evaluation. I'm going to give you examples in all of these. This is a diagnosis wizard that my company Modria built for the Ohio Board of Tax Appeals. So if you're thinking about filing a tax appeal in the state of Ohio, this diagnosis wizard can walk you through all of the main questions you might have. Is it worth me appealing? Do I have a strong case? What are the steps? How much is it going to cost? We have calculators where you can go in and put in, this is what I think my house is worth. This is what the state thinks, or the assessor thinks it's worth. And then we actually go through the calculation and say, okay, well, how much is this process going to cost you? How much money can you save? We have all of the case law that's generated by the Board of Tax Appeals. It's not really, it's an administrative law court, but all the decisions are available full text online. So when you go in and say, hey, am I going to win? We say, well, what kind of evidence do you have? Well, I have a proof of a lower sale. Okay, great, you're probably going to win. Here's the relevant case law. Well, I say the economy is bad in the area around my house, so I think the assessment is wrong. Well, you're probably going to lose, and here's the case law. So people are getting very savvy about how they use these online diagnosis wizards. Again, you don't have to even file a case to get access to this, but you can imagine for your divorce or for your landlord-tenant matter or for your e-commerce case, to have a diagnosis wizard to walk you through this process is enormously valuable, and it can set an expectation before you even begin the process of what a likely resolution would look like and what, how long it's going to take and what information you need to have going into it. Now, this is an example of something we're building at Tyler Technologies, which is a mobile-enabled diagnosis wizard, and it's what we call a conversational interface. So you can see Terry, that little icon there. Hi, she's waving at you. I'm Terry. What's your problem? And you can go in and type whatever problem you have. And using natural language processing, we can triage your case and put you into an appropriate resolution process. It asks a series of questions. It finds your location, so it can apply the relevant local law and point you towards the right resources. And eventually, this conversational interface can generate options in terms of, okay, you can go to the court, you can work with a mediator, you can use our technology to negotiate directly with the other side. The other thing that's beautiful about these conversational interfaces is they work by voice. So you can go to your Amazon Alexa and say, Alexa, you know, talk to Terry, resolve my dispute, and then it can walk you through and use all the same information. Now, now we can start to get into intake. So post-diagnosis, so people say, okay, I do want to follow through and file a dispute. This is from a process we built in the Netherlands called the Rechtwijzer, which was for the Dutch Legal Aid Board. And you come in, you put in your information, and then we start to ask questions. Okay, and you see the circles that lit up on the top. These are all of the questions that need to be answered in order to kick off this dispute resolution process. And again, like Jim Fishkin talks about out here at Stanford with deliberative polling, you can educate your parties a lot by asking them questions. So we say, how many children under 18 are you bringing up together with your partner? Now that's a very specifically worded thing because you're not necessarily married. But if you say 0 children under 18, well, then we can gray out that children's circle up at the top. And then you don't have to answer those questions. So by asking these questions, we can also provide pre-configured solutions. So we say, okay, how do you want to handle co-parenting for this child that is younger than 18 years? Here, and it's almost like the McDonald's Happy Meal. I'll take a number 1, I'll take a number 2, I'll take a number 3. You don't have to explain everything. These are pre-worked out. All of the details of these plans have been created by the Dutch Legal Aid Board. You can click other and you can come up with your own plan. But what we often do when we say to the parties in a family dispute, okay, here's a blank legal pad. How do you want to handle co-parenting? And a technology-based platform can come in and put options on the table that you know cover 85% of the cases. And if both sides pick the same option, great, you've got a plan. Again, this is the process that Modria has built for the courts, and we just launched this week in Los Angeles. That's a court system in the United States. When people come in to build their parenting agreement, it's almost like TurboTax. We walk them through each area and we present options, and they can decide, okay, custody, do you want joint custody or do you want sole custody? And if you want sole custody, do you want it to be with you or do you want it to be with your co-parent? The complainant can come through and fill out all their preferences. The respondent can come through, fill out all their preferences. They can save their progress at any time. It's asynchronous, so they're not in a pressurized environment where they're looking at the other side and they have to decide immediately. They can both put in whatever their preferences are. And at the end of this process, we can deliver to them a rubric. This is before a mediator even joins the case. And it says technology has walked through both parties through the intake process and they already have agreement in 8 out of the 9 areas. And now you as a mediator, you can come in and you can look at the one area where they didn't reach agreement and see what their 2 proposals are, and you can focus your energy there. So that's just an example of how the fourth party, by walking them through its intake process, can achieve some early wins in terms of agreement. And then when the third party joins, they can focus their energy on the area where that energy, where their attention can most deliver benefit for the parties. Now, another thing that there's a lot of work on is sharing information, as Ethan mentioned, data about prior similar cases. So not only can you provide a database of outcomes achieved in similar cases, you can also provide data and say, look, you said you have a landlord-tenant dispute. You said the amount of the security deposit is $600. Based on the last 3 years in this courthouse, these are all of the outcomes that have been achieved. This is the bell curve of all the outcomes that have been achieved in cases that look like yours. And you can present this to the parties while they're even in the middle of informing the court about this case or informing a dispute resolution service provider. And it can get pretty sophisticated. You know, maybe we're not talking about how much money am I going to get back? You know, how many days do I have until I move out? How much am I going to get back? Well, based on all the data that we have, this sort of seems like where the sweet spot is. And there's a bunch of different platforms. There's one called Pictured It Settled by a mediator in Texas named Don Philbin, who's gathering tons of case data, and you can put in the initial offers from the parties, and it'll show you what it thinks the likely outcome zone is. So there's a lot you can do in terms of presenting this data to set reasonable expectations for the parties. Many of us who are mediators have the experience of one party comes in and says, yeah, I'll pay $50 to make this go away. And the other party comes in and says, emotional damages, I want $10,000. And it's just going to be a bear to get those parties anywhere close to an agreement. And it's because they had nothing to set their expectations. So, you know, some cousin told them, well, you can probably get treble damages because, you know, you had to take time off of work, which makes no sense. But if you have a process that can help to set reasonable expectations grounded in data, then you can help the parties find a meaningful ZOPA. Now, we were talking before about blind bidding, and CyberSettle was the earliest proponent of blind bidding, although there was there were other settlement mechanisms as well. There was click and settle, and I think there were a couple that were based in the UK. As Ethan mentioned, in 99, 2000, 2001, there were just a bunch of these companies that came out. And this notion of a ranged offer, I mean, it's leveraging game theory to say, instead of, I'm going to put my offer on the table, you put your offer on the table, and we do the salami slicing. Maybe what we can do instead, and this is actually a screenshot from Modria's small claims platform, we can say, okay, how much money do you want to settle your case from the automotive mechanic who wrecked your car or messed up your axle? Well, I want $1,000 because, you know, that's what I think the total amount that I need to get paid in order to issue. Okay, we say confidentially, what's the lowest amount you would be willing to accept to close this case? And we're not going to share this with the other side. Well, I'd probably accept $800 or more. Okay, great. We contact the counterparty. Hey, this person said they had this issue with you. Here's their evidence. They want to get $1,000. Are you willing to pay them $1,000? No. Well, how much would you be willing to pay them to close the case? I'd pay $900. Bang, we have an instant resolution, and it settles at $900 because we already know from the complainant they would be willing to accept down to $800. So again, there are many ways that you can use game theory to streamline the salami slicing process. And one of our good friends, Jim Ring, has a website called Fair Proposals, and he's actually got a bunch of these different game theoretical mechanisms for incentivizing parties to be reasonable in their offers and then using fairly simple math. Now, this is not AI. This is not machine learning. You know, this is pretty much just, you can go in and you can look at the algorithm and you can see how it works. We used to call, back at mediate.com in 99, we used to call click and settle click and stupid, because it seemed pretty stupid to us. You have a settlement range. If two offers come in and they're within the range, you settle for the median. That's not that complicated. But if both sides buy into that algorithm and they say thumbs up, CyberSettle can go through and they, you know, click and settle could solve 20, 30% of your cases. Jim's proposals are a little bit more nuanced. How am I doing on time? Oh, not so great. I'm going to wrap it up soon. Smart Settle is a very powerful platform where both sides can come in. It's not just one offer on each side, and then you settle for the median. You can have many different offers. And this link here, I think we're going to share this, gives you an hour-long demo of Smart Settle actually mediating or resolving the dispute between the Biden and Bernie camps, where they, on all of these different issues, education, climate change, defense, taxes, total spending, and they put it all in, they put in the preference curves, and Smart Settle does the mathematic optimization to deliver an optimized outcome. So Smart Settle is an amazing platform. It's very, very powerful, and I urge you to watch that video so you can see how it works on a very complicated dispute. Just 2 or 3 more slides and I'll hand it over to Jan. The whole notion of single text negotiation is very powerful, obviously, but technology can make that real in terms of putting everyone into a jointly editable template where people can edit in real time and they see the text components being submitted by the other parties. You can even give them the framework of all the blanks they need to fill in, and the parties can go in and generate those. And we've seen disputes, complicated disputes, where all the parties come in, they jointly create a settlement agreement. At the end, who wrote this agreement? Well, we wrote this agreement because everyone contributed their text and we all jointly edited it. And that's a very powerful dispute resolution approach. And the last thing I'd want to refer to, again, Ethan talked about what they're doing in Alibaba and Taobao with crowdsourced justice. This is one that we designed for Marktplaats, which is the #1 e-commerce site in the Netherlands, where you have, they call it the gebruikersjury, where you bring in a bunch of uninvolved community members. You've tested them to make sure they've never transacted with the disputants. They listen to both sides, they render a decision, and it's enforced by the marketplace. And these are not 12 angry men. These juries can be 50 people, 100 people, 1,000 people. Technology makes this very scalable and very efficient. And we found ways to do these crowdsourced juries very efficiently. So the last thing that I'll mention is where this is headed eventually is where both sides are going to essentially empower a bot, an algorithm, to negotiate on their behalf. And we're seeing this in sites like Fair Claims and Do Not Pay. These are sites where you as an individual complainant can go fill out a form, and then essentially the technology platform then goes and files cases and advocates on your behalf and tries to get an outcome for you. We also see sites like econciliador.com, which is where companies are creating bots. And when they're trying to collect from users, they create a negotiation profile and they say, hey, you owe us this amount of money. How much money would you be willing to pay and when? And then the bot is empowered to negotiate against that consumer to try and find a resolution. Eventually, what we're going to see is just like in finance, where it used to be people on the floor of the stock exchange shouting out orders and holding pieces of paper, all those people are gone. Now it's computers that are engaging in those trades. That's where negotiations is going to go. That's where the law is going to go. We're still going to have more people employed in the law and in dispute resolution than ever before. But what we're going to be doing is designing and coaching these bots and then releasing them to go out and negotiate against each other. We're already starting to see a lot of this occur. And I think this is where really machine learning and artificial intelligence will add value. So I'm not going to get into this, but the ability to write agreements, to write final documents, and then automatically file them in closed cases, another powerful aspect of the fourth party. So with that, let me end my component. I went a little bit over too. I'm sorry about that. But I want to hand it over to Jan to talk about all the great work she's doing in systems design. So Mike, can I hand it over or do you want to talk further before?
No, please do. And thanks for a terrific presentation. So we're 2 for 2, and I know that it's only get stronger because I know Jan and I've come to know my cousin Leah a little bit.
All right, Jan, you're up.
Okay, I should be unmuted and I should be, am I sharing screen?
Not yet, but we can hear you.
Oh, okay.
Perfect. Now
Cool.
we see it.
All righty. Good afternoon, I think, to a bunch of you. Good morning to some of us. I'm really delighted to be here. Thank absolutely Mike and Jim and Laura and the Program on Negotiation for gathering us all together and giving us this space to share our work. I'm going to try to lickety split because I'm building on both Colin and Ethan's work before, but I want to go through a different lens, which is to look at systems instead of select processes for single dispute types. So first, I want to thank Jean Brett. She was with us earlier. It's her early work with Bill Urey and Steve Goldberg that really launched the whole area of dispute system design. So hopefully I am building on the shoulders of giants, really. But at a simple level, to think about system design as one or more processes to prevent, manage, or resolve a stream of disputes connected to an organization or institution. So clearly, I think that synthesizes what we've heard so far from Ethan and Colin and the examples shared. There are myriad of systems out there. We have public and community justice, including the courts. We have commercial, which we've talked about from companies and employment perspectives. We have international and transnational systems. So all of these call on what we believe are about 6 elements to help analyze a given system and think about the choices made and available and how to connect them with AI and this new field that we're introducing. The 6 elements are goals. What are we trying to accomplish? What kinds of conflicts do we seek to address? This is important both because if we know what our goal, where we're going, it gives us an opportunity to focus the elements of that system in a way that is going to be productive, and also to evaluate later whether we achieved what was intended. Stakeholders, who cares, who's affected by this system and its processes, how do context and culture line up, what are the process options that we have, and how are those processes connected, and who decides? And then the resources, do we have a bicycle budget, but we have a Cadillac system? And how do you synchronize the capacity of humans and the data and the finances all to synchronize in an effective way? And how transparent is the system? And is it successful? Do we know what our goals were and how have those panned out? So I really only want to look at two of these elements today. One is the goals, and two is the process options. So a very stripped down and not nearly as pretty version of Colin's graphic on the different processes, but I want to focus on the process types and the elements of them, in particularly the presence of a neutral, the presence of an agent, and where decision-making and process and outcome sort out. So looking at particularly, I want to go back and look at the process piece, and I think this is where the link with AI becomes really interesting. Processes that are through ODR are really a difference in kind as well as a difference in number. So the efficiency offerings by the various ODR options that have been discussed should help us know that we can do more cases and faster, and sometimes way faster than what humans could do. But there's another change which Colin touched on with the characteristics of these ODR processes. Are they synchronous? Are they asynchronous? Are they textual? Are they visual? And what are the processes? So we're really looking at a difference of experience in the whole nature of user experience in following these processes. I caught one chat comment by Susan asking that this seems pretty nifty, but what is the participant's experience? And could you do something multi-party that includes values and is a much more complicated environment in which to make decisions, and would it be trusted in the same way that you could do in person? And I think it's absolutely the question you want to be asking in terms of the process linked to the user's needs and interests, but I think it's also a question of compared to what. So eBay got started because there was no what. People were not going to go to court over $100 dispute cross-border. But so there are certain kinds of access to justice issues that I think AI and the use of ODR has really introduced. So if we want to look at goals, thinking about all of these possibilities to increase efficiency, access for parties to some kind of a justice system, the experience of being able to express your needs, concerns, and explore options, how to enhance reputation, technical capacity, transparency, data collection for improved analysis and prediction around decision making. So all these goals are pretty wonderful, but a question of which are most important and who decides. And often it's not going to be feasible to achieve all of these goals in one single process or even a single system. So thinking about the power and control issues, who designs the system, the process options that are comprise it, do all the parties participate? Do all the stakeholders get a voice? Is it one party, a third party? Is it a regulatory sandbox that Utah, the Supreme Court of Utah used in redesigning its court system and using ODR? So who selects the process for a given case? Once the system is in place, does a party get to decide? Does the third party tell you what you get? Does the court say, go to this door for mediation and give it a good try before you come back? And hopefully our court will be open at that time. Or does technology shift parties down to different doors and different paths? So thinking about the power and control questions and how these arise. I think what is interesting is that AI is really intervening at all these different points. So from what we saw yesterday with immersion, and is that an avatar, which is the front side of the data and decision-making capacity, can take the place of an agent, and a non-legal lawyer, or maybe a legal lawyer. It could be a party representing you. It could be a decision maker, a third party, or it could be a fourth party. So we can imagine all of these different versions out of the AI sphere as playing a role in these processes. I think an issue that is now emerging is the whole notion of regulating, and who and how might we regulate the use of AI for each of these functions, and thinking about the roles they can play, the agent, the party, the neutral, and what are we going to learn about from the regulation of autonomous vehicles, autonomous weapons, that are ahead of dispute resolution in terms of their development and regulation. So the whole notion of who regulates, and again, who has the power to design the process options in the system as a whole. So I wanted to take some examples just to illustrate this. This is way too many words on too small a space for you, but I will tell you what is there, and then we'll look at just a couple examples for application. So I've laid, on the left column, I've laid out all the elements, and then across the top, picked 4 examples, some overlapping from Colin. One is eBay, which he talked through, the courts and tribunals and their use of ODR. Again, that Colin touched on that. I want to add on Nextdoor and the use of social media, and then Kleros, which has been developing processes for dealing with disputes on the blockchain. So thinking, I'm just going to narrow this down so the words are a little more accessible. Thinking about the goals. So what are the goals for the Nextdoor social media? I don't know how to do a poll, or I would ask how many of you are on Nextdoor and have experienced their processes. But thinking about how can the neighbor group and community intervene to deal with things like bullying, sharing information, promoting civility, politeness, and neighborliness. So this is a specific area in the social media sphere that makes us think about what are the goals, what are the priorities, and who decides. The processes they've made available are discussion forums, technology, and the designer is the leadership of Nextdoor itself. Kleros has defined its goals as being fair, transparent, scalable, and self-administering. The processes, they have online evaluation, they have crowdsourced jurors, and which is Colin touched on, and really thinking about how many jurors can you involve, and does that achieve trustworthiness, the convenience, and the expertise that Ethan was highlighting. And thinking about how Kleros has really drawn on the whole worldwide developer community to enhance its processes and how they move forward in dealing with an increasingly complex set of disputes. Oh, that's a book if you'd like to read more about 6 elements of system design, and really thinking about how the applications that we're talking about here can be enhanced in the criteria and assessment process that one would go through in making the choice and governing around the system development and design.
Jan, I
Yes.
had just made myself a note to
Yeah.
plug your forthcoming book, and I'm so glad you put it up there. June has 30 days. When is it going to be out?
My co-author received her copies yesterday in the mail, and I understand that people who pre-ordered should be receiving theirs momentarily. I personally do not have a copy yet, but I expect to have one soon. So thank you.
What an accomplishment, Jan. You and I have known each other for a long, long time. Wonderful from my point of view, and it's going to be great to see your book out. So I just wanted to jump in with that
Yeah.
to a little more forcefully tell people they will be greatly informed by your work. So thank you very much for the presentation.
Thank you. I hope I lickety-split it through because I wanted Leah to have plenty of time for the issues and to answer questions. So thank you.
Great.
Great. Thank you, Jan, and my other panelists, Ethan and Colin. That was fabulous. Let me just pull up my slides here. Wonderful. So I'm going to focus on ethics. And I guess I want to say from the outset that I see there is an important relationship between talking about it on an abstract level or on a moral and philosophical level and grounding it directly and practically into systems design and practice. And I hope to engage in that connection or that tension throughout. My particular interest is in how we look at what we're actually building or accomplishing through the lens of ethics, but for the purpose of increasing access to justice. So as has already been mentioned and is quite obvious, right, from the previous presentations and what you all know already, is that we've seen this slow but steady increase in the use of technology by ADR and by courts that has suddenly turned exponential in the last several months. But you can see below here with things like e-calendars, financial software, collaborative document writing, etc., the growth of use of AI in managing processes and generating outcomes. There's been steady engagement and growth on that level. Frankly, a lot of that has come from both entrepreneurs and from the commercial sector, where there are lots of platforms that are out there and there are fewer mediators and arbitrators that are utilizing them. And I think we're going to see an enormous shift now that everyone has to. Part of this larger terrain as well is the fact that we already have over 1 billion cross-jurisdictional e-disputes that are happening. And the complexity of handling them across geography, culture, language differences, and differences in legal jurisdictions makes it both an exciting environment and also complex. And as Jan previously mentioned, many of them are inaccessible to court redress. But we want to add in the fact that big data is at play while we have little transparency. So I argue that the implications for this is that technology magnifies the opportunities, but also the barriers to access to justice. And that's going to be the focus of my presentation today. So I want to talk in a couple slides briefly about some of the ways in which it enhances access to justice. Clearly, it can enhance efficiency with being cheaper and being faster, providing options for people to participate rather than wait to meet in person or even wait to meet synchronistically online. We now can have all these opportunities to engage asynchronistically, which can increase the speed and also give people a chance to do the work on the case, whether they are the third party or they are one of the disputing parties, in a time and space when they are most clear and can be most productive. We also have AI contributions, which can increase efficiency as well. And as previously mentioned by Ethan, and I make a plug for Orna and Ethan's book, Orna Rabinovich-Einy's on the call as well, and they did a brilliant book called Digital Justice and spent quite a long time talking about dispute prevention and detection and the very significant role that technology can play in that as part of machine learning and as part of structuring in dispute systems design ways to identify early, which of course leads to a reduction in liability, a reduction in harm. Building on what Ethan said regarding e-health records, if we have a mistake that is just irritating, it's quite different than if you have a mistake about a diagnosis or an absence of a diagnosis in a health record. So doing dispute detection early can actually save lives. And then we have the fact that when we add technology, it can offer opportunities both for human and artificial intelligence contributions to creativity. In an early study we did a number of years ago at the National Center for Technology and Dispute Resolution, along with the National Mediation Board, we found that when you have multi-party disputes, that when we gave them all the parties an opportunity to contribute during a brainstorming phase, and they could contribute anonymously, we got more suggestions and we got more creative suggestions that led to more creative outcomes. So the ability to offer through technology anonymity can also add to creativity. And clearly using technology can make it easier to handle not only more cases and more issues, but to do so with clarity. Technology also increases risks. Some of this is quite obvious, but I want to highlight some of them. So I argue that it can reduce procedural and substantive access to justice. When we have inaccurate data and then we compound that by having that make a large impact on either dispute systems design or machine learning, then it can lead to an unfair distribution of benefits, for example. We also can have lack of transparency. So I would like to think about the fact that with the lack of transparency, for example, we could have bad actors that could decide that they will give different processes and different outcomes to different populations, whether that's based on being a repeat player to a business, for example, whether it's based on zip code, which can be used as coded language for who has money to come back and buy again, or based on other identity factors. And then we can also have the non-purposeful lack of transparency and being able to examine ways in which a process or an outcome is being designed in ways that perpetuate an inequality. So the lack of prevention and accountability mechanisms that we have regarding the application of technology to dispute resolution is also concerning. So handling disputes at least partially online or entirely online, or with the introduction of artificial intelligence, is an exciting place because there's new challenges, there's new contributions, but it also means that we're not aware of some of the inequalities or inefficiencies that are occurring as well. So I want to give one concrete example, as I said, moving from just abstract to the concrete. So let's picture a mediator, let's say, that decides to take the mediator code of conduct from their membership organization, let's say, and live up to it regarding confidentiality. And so they include in their opening statement when they meet with the parties what they're going to do and what they ask the parties to do regarding confidentiality. And I would say merely importing an offline face-to-face oriented standard that has been well used and used productively in the offline world, and merely importing it into an ODR setting can raise party risk. So for example, if we require that parties at the very beginning agree, and not all mediators ask parties to agree to hold things confidential, sometimes we just say, I promise. But if we ask the parties to agree to confidentiality during the process or after the process, including in their data exchanges, and they agree, and then I would argue this does not address all the ethical issues and risks that are raised when we employ technology. For example, you may either do a video where you're explaining your confidentiality and your process, your opening statement, or you may send a document or provide access to a portal through which they read this information and click yes. However, that does not help folks that are not familiar with your ODR process. There are so many platforms that are out there. They may have used one before, but you're using a different one. So they don't know that they've just agreed to participate in a process in which there's going to be video conferencing. And the other party could break the agreement and could record it, and it could appear on social media the next day. They may be exposed through an e-calendar, for example, app that, let's say, a family mediator decides to use, and that app includes location features. And they've agreed without consent to use location features, which, as someone raised in the chat earlier, can be an issue, especially when there's issues related to safety or domestic violence. They may be required to use software when they don't have the skills, and this can create or highlight power imbalances between the parties. Think of, for example, in a workplace setting where one party uses technology every day and the other party never has to use technology in the workplace. It could lead to potentially an engagement in a process in which they lose their right to access to court. Obviously in the EU, there's protection for that, but in most countries elsewhere in the world, there's no protection for that. And they could have signed up to use a process where algorithms will facilitate the movement through different stages, or literally provide options for outcomes, which structurally determines, as Colin talked about, a narrowing, and Ethan talked about, a narrowing of options, or literally makes decisions for the parties. So I would say, from my perspective, we already inherit a legacy of ethical concerns, and I've just named several here, regarding access to justice from ADR. And despite all of our best efforts as a field, we still have challenges about, and deep debate, important debates about how to handle power imbalances. Is it neutral to do nothing because I'm not changing the relationship between the parties and choosing sides? Is it neutral to balance the power, just as an example? There has been debate for the last 30 or 40 years around what happens with the preferences that happen when we have a neutral that knows one party because they regularly see them at the arbitration table, for example. And then there is a growing literature over the last 40 years, and certainly a lot of sidebar conversations around inequality for process and outcomes based on gender and race and a variety of other disability, for example, and other factors that are not related to identity. So we have this legacy that is already existing in the field of ADR of ethical concerns that have not been effectively enough addressed. And then we now have these a new set of ethical concerns with new input points and methods. What else do we not know that's going to be a challenge and increase some of the problems that I mentioned above, and some that we already know? For example, one party knows how to use technology and the other doesn't. Then when we add big data and the ability to compound inaccurate data, and we talk about process capabilities and integration with mega systems, with links to social media, through apps, for example, links to the internet, or to larger systems like a court, and then we have a lack of transparency and accountability. So if we put all this together, I would argue there's a need for ethically driven systems design, monitoring, and accountability mechanisms that are based on shared ethical principles and standards that specifically account for technology-infused dispute resolution. So in looking at ADR, trying to look at the foundation and what it has to offer, the next step in ADR, the step that's already here, ADR plus technology, is we have a set of shared values already. Norms, guidelines, standards, regulation, etc. They're fairly standardized, but they don't always translate across jurisdiction, whether that's legal or whether that is cultural. And ODR and technology are virtually absent from ADR standards and regulation. But in the subfield of ODR, that vacuum is filling up. We already have the beginnings of legislation and regulation and discussions about standards. And we have significant challenges around standardization and regulation across jurisdictions, and that's even across sectors. What's appropriate in family mediation that's very different than, let's say, commercial arbitration. And I think this is, I'd like to make a plug that all of you are included. This is really an opportunity for stakeholder-driven impact on standards development and implementation. One of the things I find most exciting about our conference meeting yesterday and today is how interdisciplinary it is. I saw that we have people from public health, people from mathematics and computer science, psychology, the legal field, legal education, dispute resolution, and we need all those fingerprints on the development of ODR standards and guidance. I also think that ADR has been insufficient in having end users have their fingerprints on standards. And so again, this is a chance for us to do an even better job. So the National Center for Technology and Dispute Resolutions put out a set of recommended principles and standards in 2009. It's exciting to know that the ICANN has been using them to manage the domain name disputes for several decades. And we recently put out a set of ethical principles as well. I want to highlight emphasize very clearly that the ethical principles for ODR are a set of shared values. They're not rules. So they're not standards to hold people accountable. Rather, they're this larger GPS, I'd call them, for providing some kind of guidance that are both based on shared values, but provide a flexibility in interpretation that's more appropriate given the setting, as I said, across culture or jurisdiction or sector, that they are large enough and high enough level that they can be flexible as new technologies develop, and also provide guidance for the development of standards for which we can hold each other and systems accountable. So in working on this, and I've been one of the people very active in the development of these ethical principles, I took great pleasure and excitement in reading the incredible work by the Institute for Electrical and Electronics Engineers, who spent a number of years developing ethical principles and standards for AIS. And I encourage you to take a look at them if you're not familiar with them. You can see here just some of the ethical concerns that are addressed by this unbelievable consensus document that tens of thousands of members agreed to together. And you could see some of the overlay between the concerns that we have in ODR, which our brothers and sisters in IEEE have as well. So here, I know you're all like holding your breath. Here's the ethical principles for ODR posted on odr.info, our website. And they should look fairly familiar because they do reflect the norms and the traditions of our field. But each paragraph that describes them has technology at the center. It's not an add-on, right? So there are ways in which we hope that they'll be contributing, as I said, flexible, forward-thinking, responsive GPS for practice and systems design. So I'm going to give you an example. Here's the competence principle. And feel free to read the whole thing, of course, but I want to highlight one component. ODR systems, processes, and practitioners will be competent in or provide access to relevant technological or human competency required for the effective implementation of the dispute resolution process. So this actually should be a guide to a practitioner who says, oh, I now need to think about how the parties will be able to access and understand how to use this. Should that be in my opening statement? Should that be something that I do with each party separately? And also, what are the ethical dilemmas of that? If I'm used to beginning my session with both people present at the same time and I don't have a prior relationship with them, excuse me, then what will it mean if I work with each party separately and coach them, right? And I do tip my hat to Lawrence Susskind, who told us many decades ago that it can be extremely important for us to do technological support for parties separately in order to make it possible for them to participate. And so we're not offering that we're the only ones that have thought about this, but we do think they belong overtly in what we hope will be standards of practice, but certainly guidance regarding ODR. And here's the integration principle. And again, I want to just highlight a couple things here. One is that whoever is creating a system or importing the use of a system into a larger mega system, we think about ways in which that process can be connected seamlessly with the rest of the mega system. So when a community mediation program is linked to a courthouse, how are they going to e-file share, right? What about the security related to that? And then we do highlight the attention that should be, the light that should be shown on public entities to make sure that the systems are designed in a way that enhances inclusiveness and access to justice.
Let me just hop in very briefly here. I don't know how much more material you have.
I'm at my conclusion, Mike. Thanks.
Good. I mean, this has been fabulous, absolutely fabulous. But I just wanted to give a little time check here. We've got a dozen or so minutes left. Okay,
so in conclusion, I would say technology magnifies both the risk and the opportunities, and that ethical's ODR systems design and monitoring are key. And hopefully the ethical principles and standards for ODR can serve as a GPS. The International Council for Online Dispute Resolution used the ethical principles to set up a working document on standards. And so you can look at the ethical principles at odr.info and ethical standards that are based on them at icoder.org. Thanks.
The thanks go to all of you on this, and we've got 10 or so minutes, but let me say a couple of things quickly. One is, obviously you have to choose which track you're going down, but Samir's track on social and cultural implications of the things we've talked about, I think will nicely complement what you four have covered, especially Leah on the ethics. Second, I should have said this at the top, but our last sessions, and that includes Samir's, run from 4 to 5:30. We're going to ask people to stick around for another 20 minutes so that we can do a wrap together. So if you can build that into your plan, wrap with a W, I should say. Though I think wrap with just RAP might be kind of interesting too. So just want to give you a heads up on that. I'm going to leave it to our chairs here, Colin and Ethan, on how to bring this together and next steps and so forth. You've covered some of that, but how can we make good use of the few minutes that we've got left, Colin?
Yeah, Mike, I'm definitely going to hang around at the end of the day if it means I get to watch you spit some fire. So let's see what happens. We've had a really good interaction on the chat and lots of back and forth, but Larry just asked a great question that I'll surface. I want to call out the question that Susan raised about sort of dealing with the psychological realities of participant experiences in ODR. There's been a lot of valid criticism about online dispute resolution systems kind of pushing parties into the quote unquote little boxes approach. I think that's what Robert Conlon calls it, where you sort of simplify disputes and they just go through and click a form and say, okay, well, here's your outcome. Is it really meeting the psychological complexity of the party experience in trying to reach that resolution? So I think I posted a link to Gene Sternlight's excellent article about that, because obviously Gene is the expert on the psychology of dispute resolution. That's definitely a hot topic and definitely would go beyond the scope of the time that we have left. But I wanted to touch on Larry's point. He asked, how do we enforce ethical norms, principles, and rules? Do we expect mediation to stop as soon as an ethics complaint is filed? Who enforces mediation ethical standards? So Leah, can I go to you for an answer to that?
Sure. Well, I have a response. I'm sure I don't have an answer. And I would be thrilled to hear Larry's point of view on that. I've learned so much from him over the years. So I guess to me, that is one of the very important distinctions between a set of principles and a set of standards. So I just want to begin with the principles perspective. I'm an advocate of having a set of principles in the absence of having agreed standards, because it is, again, it can provide guidance and also preventative. It could cause us to think reflectively and engage. We could engage with our co-mediator or facilitator. We could engage with the parties themselves around that. And the other thing I would say regarding standards, not being a very rules-oriented person, I still think that standards can be useful for us to have, for us to hold ourselves as members of a field accountable. So I'm not certainly in a position to argue that you need to stop a mediation the moment that someone challenges whether a party or the mediator is being unethical. I also think that that's a heads up. If we go back to our core issues around relationship building between parties and the third party, or now parties and the fourth party, that if someone raises an ethical issue and says, I feel like I can't trust this process because I don't understand what AI is doing, rather than have us shut down, for me, it's an opportunity to say, oh, it sounds like there's a lack of trust here. I'd like to hear more. It's an opportunity to open up. So I'm not interested in this being a way to shut down process, but a way for us to have high enough best practice standards that we have, what's the word? We have both something that we're aiming for, and also I'm especially concerned with the application of AI where parties do not know when it's being used and when their options are being shrunk, or decisions are being made that literally could be designed to give one type of party one set of processes and another type of party another set of processes. And if we're developing the field, I think there should be standards for us to be thinking about these things. So I don't want to put you on the spot, but I'm sure you have a lot of great ideas, and I welcome you to engage back.
Larry?
Please, Larry.
I'm happy to elaborate on the question that I put there. When SPIDER used to be around, the Society for Professionals in Dispute Resolution had an ethics committee, and I had the misfortune to be a member of that ethics committee. And there were a number of instances in which people felt after the fact that their mediator had not been fair, to use Michael's word. And they wanted the ethics committee to investigate. And since the rules/norms/standards were so vague, it was pretty hard to know what to come up with as the product of an investigation, except some kind of confirmation that the mediator did X. Yes, indeed, the mediator did X. We had no power to then go to that mediator. We were supposed to report to the association. And presumably the purpose of ethics investigations is to focus on the reputation of the individuals providing the service so that other consumers have some kind of warning, which means you have to publicize something in some way. All of which is to say that if you think there needs to be ethical oversight or ethical reflection in the ODR world, you're going to have to do it. There's going to have to be a professional organization that knows something about this, that sets enough information down to make promises to consumers and makes some kind of statement to providers so they know that they'd be treated fairly. And the problem, the reason I asked, do you shut things down, is if there's an outcome of the mediation and the other side acts on it, and you're still back at the point where you're outraged at something the mediator did, and that, I guess you can just leave and say that's the basis for it, but you think the substance is important to get a result, do you sort of continue with a notice? When are ethical issues explored? And then say they're explored. What do you do with that, and how do you help providers get better and consumers be treated fairly?
What's interesting is the United Nations Working Group on UNCITRAL Working Group on ODR spent, 8 years plus trying to figure that out. And in sitting through those meetings, I was thinking, who's losing out while we have no agreed standards? So I agree with your concern and your challenge back to all of us in the field, and the way you framed it, Larry, it's excellent. And that's one of the reasons I thought there's a need for ethical principles, which we don't use to hold people accountable other than ourselves, but we can use as stimulation for thinking, what am I not thinking about? And for those of us who are not used to practicing online or employing technology, to say, if I'm going to start to do this, this can give me a template. But I think that your challenge back to any organization that's developing standards is excellent.
Yeah, and I
Anybody
would
else?
say too,
Oh, go ahead,
please,
Colin.
Mike, I was just going to say, we've created ICODR, the International Council for Online Dispute Resolution, to achieve many of these objectives. But several of us have served our time in the trenches of the ADR field, wrestling with certification, wrestling with investigations, and we don't want to we want to avoid as many of those sand traps as possible. Unfortunately, there's no clean answers. I think you're right. If you're going to do the work, if you want the work to be done, you got to do it yourself. I think that's wisdom. Jean asked one last question. Maybe we can sneak in before we hit our turkey timer. Is the reason that ODR procedure is so successful in resolving disputes without addressing party emotions is because the BATNA is so poor? And so I'll weigh in on this quickly. I do think that if you look at, for instance, people on eBay, you know, they have no plan B. You know, you can't go to the courts. It's a $75 case. Your seller's in another country. So it might be that their alternatives are really bad, and that's why they rely on eBay. But eBay, theoretically, I mean, the courts, I think, provide very questionable services to end user disputants because they are the only game in town. It's like, why is service so bad at the DMV? That's because it's really the only place you can go to get a driver's license. I think that eBay does know that even if there's not an alternative for redress for a lot of their consumers, if people get frustrated enough, they're going to leave eBay and go to Amazon. So that's why eBay invested heavily in making these procedures better maybe than they would have to be if they're the only alternative, at least in an individual case. So I think maybe, Gene, I'm bristling a little bit with that characterization because it's like, you know, people at UNCITRAL would always say ODR is rough justice. It's this really kind of, you know, brutal, overly simplistic system that's just intended to deliver value at scale. It's not really that great. And I don't think that that's the case. I think many of the ODR systems that are being built are better than the face-to-face alternatives that are available out there. So I don't know. I don't want to say that that the only reason why people agree to participate in ODR is because they have no other alternative. I think as they get better and better, it might be that people proactively choose it even when they do have alternatives. But let me go to my other panelists. Do you have thoughts about this as well?
Let me though jump in too, Colin, because I'm mindful of the time. We have a minute or so
Sure.
Left here.
I understand.
I can linger, and maybe some other people can as well, but I want to set up a standard where people have signed up for 90 minutes, and if they have other obligations, they move on.
Absolutely.
I also want to be sure that we don't wear ourselves out. We have an hour break that'll go from 12:30 our time to 1:30. I have a couple of comments on that, but I don't want to claim the last word here. For anybody who lingers, I'd be happy to jump in the conversation. Right now, I just want to say thanks to you, Colin, and to you, Ethan, for setting up. I mean, gosh, we've covered a lot of territory here and much more to be explored. So will everybody join me in a virtual clap here for all our presenters and commentators as well. We can stay on for a while, but maybe we'll shut down in about 15 minutes, and I don't know whether I'll work out, or my lunch is sounding better actually than that. So that's what I'll probably do during the break.
Or breakfast out here in California, so as the case may be, yeah.
Dinner elsewhere in the world.
I'm going to jump in just to say something, and I realize people will go to lunch or breakfast as they need to, but I think one of the things that may be a misnomer in the ADR world is that that adding technology means you do everything online, or it means there is no video. And I'm not saying that this crowd is thinking that, but I want to nudge that back into the conversation now. So for example, you can do a family mediation and all of it's through video. And I'm not saying being a mediator and a family mediator, I know that's not the same as as in person, but it provides some other benefits and it certainly provides some drawbacks. but having a chance to do it using video gives us access to engage in storytelling and emotional engagement, and a lot of things that many of us who are only thinking of it as these boxes with choices are not considering. And of course, the same thing can happen. You can do a commercial dispute and still engage. You know, it could be the car mechanic down the street and you have a long relationship with them and you know them and you're pretty frustrated at what happened and you want that, or a landlord tenant. So I guess I just want to reintroduce the fact that we're not only talking about algorithms and text, we're also talking about the use of video. And I'm on the advisory board for a divorce mediation platform, and they are specifically designing it to address emotions. So it's not finished. We'll see what happens, but there's a lot of possibility for creativity out there as well.
Yeah, and I just want to underline that, actually, Mike, before, I'm sorry to step on your toes, but I just think what Leah said is so important. This whole notion of online versus offline is a false dichotomy. Absolutely. This is about putting more tools in the toolbox. And I think, you know, we can imagine a multi-party process, for instance, where we convene everyone. We do use technology to do our pre-conflict situation assessment. We convene face-to-face. We have interaction. We break into working groups. We do lots of online work, video-based, email, sharing documents. We reconvene at the end, face-to-face. We get an agreement, then we finalize it and all certify our acceptance of it online. The notion that we have to do it all online or all offline, I think, is one of the key cognitive blocks that I think a lot of practitioners have when they think about technology, that somehow the use of technology for a dispute resolution process is criticizing the use of face-to-face dispute resolution techniques. And I think that that is not the case. If you look at a doctor who used to provide all the services face-to-face, and then suddenly they do telemedicine, they don't think that that's not medicine. And we somehow in the dispute resolution field have gotten into this thinking, well, there's face-to-face dispute resolution and there's online dispute resolution, and never the twain shall meet. And I think that that's a flawed way of thinking about it. And I think that gets to the heart of what Leah is saying. Please.
Three quick things here. One, we have 2 blocks of time coming up. You're going to make hard decisions about which one to go to. The good news is these will be posted, I think, within a week or so is our aspiration. So you're not going to miss anything. Second point is that in Mike Luca's Changing Marketplace thing, he's doing something that's a first cousinly of what you're talking about, ethics. He did a very careful study of eBay, where trust is important. You want to know that you've got somebody responsible coming into your apartment or into whatever you're renting out. You need to know if you're the renter that you're going to be in a safe environment. So what Airbnb did originally was have pictures up so that we see one another, and you look like a very genial person, Leah. But Michael did deep data analysis and saw that that was fostering bias. It was not intended, but the question is, how do you build trust and have a sense of personal engagement, but not have people either explicitly or implicitly expressing bias? That's one point. Second, to everybody else, when Leah talked about the potential bias in the programming, CyberSettle, if you remember, had a 3-round bidding process between the insurance company and the claimant, seeing if you could narrow the ZOPA. If there still was no overlap, whether they missed by an inch or a mile, nobody knew. If there was no overlap after the 3rd round, the claimant would get to make another bid. But that's not to the claimant's advantage. It means basically that they're the ones who budge at that point, if there's going to be any budging done, where essentially the insurance company is locked in. So a very simple design issue where I don't know if they are marketing to the insurance companies or what, to say, hey, listen, that's a take it or leave it. And I'm sure there are countless number of other instances where wittingly or otherwise, these things are tilted. I'll shut up.
Well, Mike, I just wanted to follow up on that. There was another provider parallel to CyberSettle called Click and Settle, and they were trying to focus on these insurance settlements. And they actually had conditional compensation in their process, right? So they only got paid their full amount if the parties reached a resolution.
I'd forgotten.
Now, of course, the ethical rules say you can't do that. You can't have conditional compensation for mediators because the mediators will then railroad all the parties into resolutions because they only get paid if there's a resolution. So they'll push them into a bad resolution because, you know, baby needs a new pair of shoes. But the thing is, the Click and Settle said, well, we shouldn't be subject to those ethical rules because it's an algorithm. The algorithm can't be biased by conditional compensation. So, you know, why shouldn't we just charge $5 to file a case and then we get, you know, 0.25% of the settlement amount? So people said, well, maybe that would be okay. But if Click and Settle actually, when you went in and looked at their algorithm, they would provide a scoring of what they thought your case was worth. And people started to go in and test their process, and they realized they were telling different amounts to the plaintiff and to the defendant. So they would say to the plaintiff, they would lower the estimated value of the case, and the defendant, they would raise. And they said, what Click and Settle said was, well, we have different databases. There's a different database that sets the value for the plaintiff and for the defendant. So it's not that we're artificially changing people's expectations, but in fact, they were, because they wanted to increase the likelihood of resolution because that's how they got paid. So we have to think about these ethical issues, not only in the performance of third-party neutrals, which is most of what our ethics standards focus on today. We've got to think about the coders, because even if you launch that platform day one, and it's offering the same amount to both sides, over time, those numbers may spread. So you have to go back and do another audit to make sure the platform is not introducing that kind of systemic bias. So I think it reinforces the point you made. Other questions, thoughts, reactions, please.
Raise your hand if you want to be called on. Hard for Jan to do that.
Larry, you got another one, please.
I'm interested in what you think is going to happen right now, where courts have no other choice but to start trying to use online methods of beginning to deal with their backlash and not backlash. Well, it is a backlash, but it's the backlog.
Backlash and backlog, yeah.
And you have completely untrained judges and judicial staff suddenly trying to figure out what to do. I appreciated the reference in the early presentation. I guess it was maybe it was Ethan's about the British Columbia Civil Resolution Tribunal and Her Majesty's online court. I'm less worried about figuring out the right etiquette. I mean, Colin knows I'm working with a colleague of ours who's putting one of these into effect in Alberta, and his big question was, do I wear my robe or not as a judge before? And then when I stepped down off the dais to now mediate, because they have a judicial dispute resolution process, do I take the robe off? And it was a big concern of his. And I was suggesting there were much bigger concerns, and none of his staff have a clue, and they don't even have a way to run the simplest kind of conversation. They're having to learn immediately. And if they set standards and they lock into certain ways of doing it, I'm very worried that the pandemic reaction is going to condition the assumptions about what online mixtures are like.
Leah, I see you nodding forcefully. Do you want to weigh in on that?
No, I just was thoroughly agreeing. I think it's going to set an expectation among the public. And I think that courts are overwhelmed and under-resourced. And I'm also thinking for trainers, there's a tremendous opportunity there. Courts need help. And so I wasn't nodding because I had an answer, but I was just vigorously in agreement with that. I was hearing from a colleague at the Justice Department Federal Justice Department in Canada yesterday that they're dealing with cases where, this is the story that I heard, that lawyers were sitting on their bed engaged in video conference with the court. One lawyer showed up without a shirt on. So what is the judge supposed to do? If they stop the trial at that point, what about the defendant or the plaintiff? What is the protocol? What's the prep for lawyers about that? Of course, maybe given that lawyer's housing situation, that's the quietest room in the house. So I think that the issue around protocol is small, and at the same time, because it's on people's minds, it's also going to be something that we're going to have to coach people to deal with. But I think the issue goes for the court itself, but also for the parties, the disputants, who have different bandwidths, right? Who have different experiences with technology, with access to technology, and then also how do we handle translation for people who would get a translator in the courthouse but aren't going to get a translator online. So I think the issues are enormous. And I think it's both overwhelming and incredibly exciting and important, because there's a chance for, again, this multidisciplinary, interdisciplinary group of people to try to figure some of this out, not just in this abstract, what would be a great best practice, but what are we going to do tomorrow?
Oh, and if I could say something.
Please.
I don't deny all of this. They're interesting anecdotes, but bottom line is access to justice is a huge problem. Time it takes to get a hearing is a huge problem. Small claims court, I had the misfortune of being involved in a small claims court case, and it took 9 months to get it resolved. So there are a lot of adjustments that are going to have to be made, but underlying all of that is similar to the telehealth issue. There are a lot of things you wouldn't want the doctor to make a judgment on based on a video. On the other hand, there are a lot of times when you want to see the doctor, you can't get an appointment, and there's minimal loss by having a video encounter. So I can't imagine a lawyer showing up in court without a shirt on, but although maybe in Hawaii they do that. But
why Hawaii?
I don't know.
Maybe
what
a Hawaiian shirt. Yeah.
Hawaiian shirt.
Well, I will say, and Jonathan, I want to go to you in one sec, but you know, this is what I've spent the last 3 years of my life focused on, is trying to get the courts to think about how can we use technology to expand access to justice. The Pew Charitable Trust has announced they're spending $250 million on using technology to expand access to justice over the next 5 years. And they've chosen 2 initiatives. One is ODR, and one is what they call litigant portals. And the National Center for State Courts, as we've mentioned, has been one of the leading advocates of ODR. They hosted our last ODR forum at their headquarters in Williamsburg. They're pushing ODR very hard. Now, the challenge is they're redefining it to be what the courts want ODR to mean. And I think some of us in the ODR field are saying, well, wait a minute, you know, like just because you send out notifications that you have a hearing coming up in 2 weeks, that's not ODR, you know? So I think that this is a big challenge, Larry. The courts want to pave the cow paths. And you have judges like, okay, I want to have my robes, I want to sit on my podium, and I want to stop the process when, you know, somebody doesn't have their shirt on. Of course, if it was asynchronous and people were participating textually, the guy could be totally naked. It doesn't matter. You know, what I never wanted to sell to the courts, ODR. I wanted to put bulletin boards outside the courthouses that said, don't go in there. Come to modria.com. You know, we'll take care of you. We're faster, we're better, we're cheaper. So I'm now starting to get to the point where there's just no way you're going to be able to get the court system to reinvent itself on the timeline that we need to operate in. And, you know, the pandemic has now urged all these courts to do hearings via video, which just doubly underscores the complete time out of joint nature of the judicial system. I mean, it is a system from 100 years ago, which is irrelevant to the way the world currently works. We need a justice system that works the way the internet works. And ODR gives us a vision as to how to do that. So I don't want to sit around and wait chief justices to say, yes, we approve you changing my form 18-36B. Like, forget it. We need to build a new system from scratch that radically reinvents the process, that uses all of our ethical lessons over the past 3 decades, and then everybody's going to come over to us, and then they can forget the courts. Susan, I saw you put your hand up, but yeah. I saw Jonathan's first.
Yeah, but I'm going to
Mike,
preempt here on both, and want to hear.
I want to go on all day here.
Good,
so,
good. But the one thing to be mindful of is we don't want to wear ourselves out. Abigail, help me out here if you can unmute. I understand that this room stays open until we close it. There's no time ticker on it. Is that correct?
That's my understanding as well. And I did just check with Laura. She says at 12:55, we have a hard stop at 1 p.m.
Okay, well, what I'm going to do is refresh myself a little bit with some reluctance, because this discussion is going great. We've got, I think Jonathan was interested in getting in, Susan, maybe somebody else as well. I'll get to see that later. But thank you, Abigail, for overseeing us and bringing good karma, all of that. And thank you to everybody who is online. I will, with very mixed feelings, sign off at this moment. I just want to be sure that I'm working at full speed for the rest of the day.
No worries. Thank you, Mike. Thanks for bringing us all together and herding all these cats. Thank you, Abigail.
I'm happy to stay on. I'll just mute myself again.
We'll just do a little bit more, and let's do Jonathan, Susan, and Ayelet, and then we'll call it. So Jonathan, you're next.
Okay, thanks. And Colin, the paper you sent out, I think touches on some of what I'm going to ask, but I was trying to read between the lines as to what the decision criteria, it sounds like some of it's classical economic things like Nash bargaining solution, but then maybe there's bringing in historical data, which opens a can of worms. And Lee was talking about maybe these different platforms have different policies based on the zip code of the person. So I'm curious what kind of uniformity or consensus is there on these decision criteria? And is that actually something also that's open to negotiation between parties as to what the decision criteria might be?
Anyone want to respond to that?
So I'll just say one thing regarding the zip code. I'm thinking about when you used to get a magazine in the mail for Sears or LL Bean or whatever clothes company, and next to your address there'd be a code. And when you call up to say, I'd like to order the shirt on page 29, they'd ask you what the code is. And so one time I said, why are you asking me for the code? And they said, because the price matches your zip code. So like, wow, that consumer affairs person, consumer representative was willing to actually tell me that I was going to get a different, higher or lower based on my zip code. But knowing that, why is that same business not going to offer different dispute resolution processes based on your zip code? Because they know your go away fee. And if they can match that to your social media imprint, not just how many people follow you or how many people are you connected to on Facebook, but how many of those people spend money or buy from them, right? So if they can gather all that data and vacuum that up, then why won't they offer you a different first level outcome than somebody else? I'm extrapolating. I don't have research to prove this other than my own personal experience with a phone call with a catalog representative. But I'm trying to give an example that the dispute resolution system that business offers, right? Just like eBay is a marketplace that offers a dispute resolution system, so will every company. They're either going to use an outside ODR provider or they're going to design it in-house. They might call it customer service, but it's basically ODR. And so as a result, we in the field may want to develop standards that say this is ethical practice, and then encourage businesses to say, I live up to that ethical practice. We may not regulate them, but they can put the the trust mark, the good housekeeping stamp to say, I live up to these standards. So this can help build trust that you're going to get the same process as some other person. So I think that there are creative mechanisms that are not about regulation as much as engaging in best practice in order to proliferate that. And I would also say, just quickly, the American Bar Association, the National Center for Technology and Dispute Resolution, and the International Council for Online Dispute Resolution are collaborating now in gathering standards worldwide that have any affiliation with ODR at all. So if you happen to know of any standard, please send it to me and I will share it with that group. Once we've finished this comparative document, we are going to make it public so people could see what different organizations are either discussing or have implemented. And then I'm quite sure that each of those organizations are then going to decide what kind of standards they want to endorse, or whether they want to collaboratively develop and endorse standards together.
Great. Susan, you got
Yeah,
our last question.
So I need to jump off for a 1 o'clock call, but first I want to thank you all because I'm hyper-stimulated, and so those were just great presentations. What happens when I get hyper-stimulated, like a good mediator, is I start seeing multiple perspectives on the same question. So where I asked the question about emotions before, I'm now starting to think about what should the justice system provide for people. So for example, when I think about family business disputes, where family members are trying to use the court system to fight battles from yesteryear, how is it that the justice system should respond to those, or how should ODR respond to those? Because if we say, well, we can't satisfy the emotional needs of family members through ODR, it gets back to, Colin, I think what you said, what are we comparing it to, right? So should the justice system or ODR have some track for emotional needs prior to entering into some dispute procedure? And it also gets to, I think, what Leah said yesterday, which I see a lot in my work, is some people need to be heard. And how do we provide a venting option, for example, as part of the process? So just some of the questions that are spinning around in my head.
Yeah, I mean, one of the things I will say, you know, this year, I know you know this, I got the Frank Sander Award from the ABA, which I was really honored. So I went back and I read Frank's speech in 1976 because I wanted to see what he said at the PON conference. And one of the things that he talked about was courts in the year 2000, which I'm sure in 76 felt like, you know, 2100, you know. But he said courts in the year 2000 probably are going to do a better job. And he didn't say fitting the form to the fuss, but essentially, you know, creating appropriate resolution channels for each dispute type. And I really do feel like that's what ODR is all about. I mean, if you look at the court processes that are provided for these emotional kinds of disputes, we essentially have seen Frank's vision has created all of these family courts where you have mandatory mediation and you have a more appropriate process because, you know, just a purely evaluative judge-based process is a horrible way to put together a parenting plan. You're wrecking all the trust you need for that moving forward. So I do feel like we've seen a certain element of transformative dispute resolution brought into the courts in some way through the creation of these specialized processes. But I really feel like with ODR, we can create thousands of multi-door courthouses, these virtual doors. And as people come in and they tell us about their issue, we can say, all right, well, this is a purely transactional dispute between two strangers. That's fine. We can use a blind bidding algorithm, whatever. We get a rule, we get an outcome. But here there's an emotional element. And then we can start to actually build in appropriate resolution processes that account for that justice journey that has emotions at the heart of it. And that's what Leah's saying with the company. I mean, some of the work we've done in the family context, I think is fascinating. My wife says, it's so creepy you do online divorces. Like people just go to a website and they get a divorce. So well, how do you think people find their spouses? It's all swiping left and swiping right and match.com. I mean, the culture has completely changed. We do things online that 10 years ago, we would have thought, no way. I mean, I remember talking with Larry about this in 2001. And his attitude was, you know, no, this is about getting people to connect. You can't just go to a website and go click, click, click on a form and get a resolution. I mean, he had that insight 20 years ago. But now what we're seeing, particularly in the younger generation, they're open to using technology for these emotional communications. And it is psychologically satisfying to them to go through this process. And if you say to them, you have to come down to an office and meet and sit at my table, that is not psychologically satisfying to them. That immediately turns them off. It's like, that's not the way I live my life. So I think you're right. There's a lot of questions we have yet to answer here. I feel that it's not only a matter of humans are not, you know, unchanging. I mean, the values, the culture, the expectations we have are changing as quickly as technology is changing society. So we have to evolve our dispute resolution processes, and things that would have made no sense 20 years ago now are the new default for some of our younger parties walking in the door. I see younger divorcing couples with no kids. They're like, isn't there a form that I can fill out online to do this? I mean, so I think you're right. That's what makes this so interesting to me, is the psychological component. If it was purely just code, that's not that interesting. But the changing dynamics of party expectations is what really makes this interesting, because it's not about where we are today, it's about where we're going.